Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Indraprasth Law College. Although we have already discussed the various topics in detail in the previous lectures, you may see it and take benefit from these lectures. And in the previous lectures, where we started the chapter of state recognition and state succession, and already discussed about the state recognition, the meaning of state recognition and the concept of state recognition in regard to the subject of international law. Now in that lecture we will discuss about the nature of recognition, includes the constitutive theory of recognition. And the next theory, that is called a declaratory theory, which will be discussed in the upcoming lectures. But in this lecture, under the question of nature of recognition, state recognition, we have elaborated the concept of constitutive theory. So let's discuss about the concept of constitutive theory and how it emerges the nature of state recognition in the interpretation of this constitutive theory in regard to the subject of international law. So according to the constitutive theory, it is the act of recognition alone which creates statehood, or which clothes a new government with any authority or status in the international sphere. Thus a new state becomes a subject of international law only through recognition by other states. We already know that about the state recognition very well. But this doctrine is rooted in the concept of international law as a legal order, which basically derives its validity from the consent of its subjects, and if we discuss about the main exponent of that theory are annuality, Calson and Lauter Pact. These are the basically main exponent of this theory, and these are the great jurisprudence writers or the jurist, you can say that. So according to the annuality, first we take about the annuality. So he is also a great jurist. According to the annuality, the rules of international law are created by an agreement. So he considered that the international law has been created by an agreement among the nations. So a subject of international order comes into being when it first becomes a party to an agreement expressing its recognition. So annuality merges the concept of state recognition on the priority of the agreement among the various nations, wherein the Calson maintains international legal relationships are established as soon as a state has certified that a community is a state in the sense of international law. So that is a basic view of the Lauter Pact and the Calson. But After a careful analysis of state practice, Lauterpact concludes that recognition is constitutive in nature. The question is nature of recognition, and after having the theories of Angioloty and Calson's, Lauterpact comes and concludes that recognition is constitutive in nature. To the objection that recognition is often withheld on arbitrary grounds, basically arbitrarial grounds, and Lauterpact responds by saying that states should have a legal duty to grant recognition. And once it is found that the new state has fulfilled all the conditions of the statehood. So according to him, this will terminate recognition being given or withheld on political grounds. However, the practice of states do not reveal or emphasize upon any such duty. Even the draft declaration on the rights and duties on the states prepared by the International Law Commission does not recognize the rights of a new state to claim recognition. That's why Oppenheim writes that through recognition only and exclusively a state becomes an international person and a subject of international law, and that recognition is constitutive of the rights and duties pertaining to the statehood, governmental capacity or belligerency. So the untenable character of this theory is clear, even from the fact that the emergence and existence of a state as a subject of international law in no way depends upon its recognition by the other states. And no one knows how many states must recognize a new state in order that it should become a subject of international law. So a new state, being a subject of international law from its very inception, enters into many kinds of relations with existing states even prior to its recognition, and in this way influences the entire system of international relations. So that's all about the constitutive theory of the recognition, which covers into some points and elaborated the main points to understand easily that concept. The number one is that the judicial practice of many states, according to which an unrecognized state or government does not enjoy the full and complete rights of a foreign state. A government before national courts points to the constitutive nature of recognition. And the second one is facts relating to the effectiveness or independence of a new regime are susceptible to different interpretations. So recognition is more than declaratory in nature. It is constitutive in nature insofar as it precludes the recognizing states from contesting the facts afterwards. Constitutive theory has been criticized on some grounds also. So there is a criticism on the two grounds regarding the constitutive theory of recognition. That is, basically the first point is there is complete absence of mutuality because recognition is viewed purely as an unilateral act over which the recognized state has no control or part to play. And in other words, you can say that recognition can be granted or withheld on arbitrary grounds and not on well established principles.